The Honorable Madam and Mr. Speakers, distinguished guests, ladies and gentlemen. Good morning. My name is Fatih Önder. I am a former Turkish judge and the moderator of today's online side event. First of all, I would like to welcome you all to this very important online side event titled The Independence of the Judiciary in Turkey. In this occasion, we shall have outstanding speeches from our prominent speakers. Before we get started, I would like to go over a few items so you know how to participate in today's event. We will be having 4 honorable speakers. Because of the COVID-19 measures and of their personal schedule, the first 2 speakers will be contributing us with their video recording speeches, and the others will be participating online. You will have the opportunity to submit text questions to our online speakers by typing your questions into the QA panel. You may send your questions at any time during the event. However, our time is quite limited, and if we have time, we will try to address some of your questions during the questions and answer session, which is at the end of the event. And while sending your questions, please indicate the speaker whom you address. Again, as it was announced on the flyer of this event, our first speaker would have been Mr. Diego Garcia Sayan, the UN Special Rapporteur on the independence of judges and lawyers. However, he informed us yesterday that he had an urgent surgery the day before, and he wouldn't be able to participate as today, either online or with a video speech. To this respect, firstly, we would like to share his very recent public statement regarding the systematic repression against lawyers by Turkish government. Here it is.
Persecution against lawyers seems not to end in Turkey. As a special rapporteur on independence of judges and lawyers, I have repeatedly called the attention of the Human Rights Council and of the General Assembly of the United Nations about cancellation of judges' organizations and persecution against lawyers that began in 2016. The recent arrest of more than 50 lawyers that occurred in the last days in Turkey is one of the most negative steps that have been taken, because these lawyers are being accused of performing their legal functions in defense of persons that the government called terrorists, which is what usually the name they use to call dissidents. The basic principles on the role of lawyers that were adopted by the UN 30 years ago established very clearly that one of the basic rights of individuals is to have the access to lawyers, and that never the function of a lawyer, a specific lawyer, can be confused with whatever is the crime attributed to a specific individual or group of individuals. I call publicly the attention of the world, of the United Nations, and of European regional organizations to react promptly against this additional step taken against the rule of law and against lawyers, which is one of the components of rule of law in Turkey or in any country. Thank you very much.
Ladies and gentlemen, sorry for the technical problem. We wish Mr. Sayan a very quick recovery and thank him for his support. Without further ado, I would like to welcome our first speaker, Madame Valérie Pey. She is the director of the International Observatory of Human Rights, which is a London-based NGO focused on exposing human rights violations in their TV channel dedicated to human rights campaigns. She will deliver a video recording speech. And now, ladies and gentlemen, the floor is hers.
Hello, I'm Valérie Pey, and I'm the Director of the International Observatory of Human Rights. This month, the United Nations commemorates 75 years working to ensure that the fundamental principles of the Declaration of Human Rights are protected and upheld. Turkey became a member of the United Nations on the 24th of October 1945. And for the first time in history, is a Turkish diplomat, His Excellency Volkan Bozkır, who is the new president of the UN General Assembly. Each of the 193 member states have the opportunity to address the UNGA, and on the 21st of September, President Erdogan used his message to call for the Security Council architecture that is democratic, transparent, accountable, effective, and based on an equitable representation, as saying it's become a necessity rather than a choice for humanity. Just imagine if he'd been speaking about his hopes to transform justice in Turkey today. I'd like to thank Press Emblem for inviting me to speak at this important event, and I send my regrets that I can't join you in real time today. But I wanted to support this crucial call to action with my fellow speakers. Justice needs to be done in Turkey for all those who've suffered under the regime of human rights abuse. IOHR and Press Emblem came to the UN in Geneva in January to hold a similar session on the eve of Turkey's universal peer review. 124 country delegations raised key issues such as press freedom and state control of media platforms, rights to protest, the removal of elected mayors, enforced disappearances, torture, and arbitrary detention, which is again very evident with the mass arrests of lawyers that we've seen in the last couple of months. The list of abuse grows ever longer. We're seeing the dismemberment of the human rights across every single sector of Turkish society. Today at the Human Rights Council, the UPR of Turkey will be adopted. Let me just play back to you some of the comments from January that the Turkish delegation responded to at the time. Since the end of the state of emergency, Turkey has focused its on reform agenda. In May 2019, President Erdogan had announced a judicial reform strategy to improve the protection of fundamental freedoms and of the independence, impartiality and transparency of the judiciary. Turkey is also prepared a human rights action plan. So where are the results? A few other comments. Turkey remains committed to a zero tolerance policy on torture. Freedom of assembly and association are safeguarded by the Constitution. There has been widespread misunderstanding concerning the suspension from duty of some mayors. There are several ongoing investigations and proceedings against those persons with terrorism-related offences and misuse of public funds. Their suspension from duty was an interim measure that has been taken in accordance with the Constitution and the relevant legislation. The representative of the Ministry of the Interior said that the procedural safeguards to prevent torture and ill treatment in the context of the fight against terrorist organisations had been introduced. And on press freedom, the delegation of Turkey noted that a provision had been added to the anti-terror legislation to ensure that the expression of thoughts did not go beyond news reporting or did not simply amount to criticism, should not constitute an offence. It noted, less, that freedom of expression was not an absolute right and did not protect terrorist propaganda, incitement to hatred or violence. Freedom of expression could be subjected to restrictions as provided for the international human rights treaties. Turkey noted that no profession, including journalism, gave persons immunity from prosecution if there was reasonable suspicion that a crime had been committed. So, if that crime is being branded a member of a terrorist organisation, it's a carte blanche to charge you with anything, whether you be a journalist, a lawyer, a judge, or someone that just happened to be in the wrong place at the wrong time. So it's been 9 months since Turkey passed the UPR and our event with Press Emblem was in Geneva. We see very little sign that the Turkish government is standing up to its human rights obligations. In fact, we're seeing an increase in further crackdown, particularly legal, civil, and media professions across Turkey. But it's not just civil society raising a warning flag. In July, the Special Rapporteur on Independence of Judges and Lawyers, Diego Garcia Servan, created a report for the General Assembly noting that the involvement of the executive branch of power in a selection of members of disciplinary bodies and disciplinary procedures raises serious concerns with regard to the independence of the judiciary and the separation of power. In several countries, and he noted Turkey here, judges are subject to disguised sanctions. According to the Global Judicial Integrity Network, judges who lack minimum institutional protection are susceptible to various types of non-disciplinary interference, such as financial insecurity, career instability, a lack of physical safety, or undue pressures arising from other institutions or within the judiciary itself. Also speaking on the 21st of September this year was Luciano Hazan, who's the chair of the Working Group of Enforced or Involuntary Disappearances. He said in his follow-up report on Turkey, impunity is a distinctive trait of most enforced disappearances, and it has a multiplying effect, generating additional suffering and anguish for the victims and their families. The international community should not be neutral in the face of such suffering, but rather strengthen cooperation efforts, increase the assistance available to the victims, and pursue judicial investigations and prosecutions, both at the local and international levels. Turkey's response was to accuse the UN Working Group of being infiltrated by FATO terrorists. I'll let you read the responses for yourselves. Turkey will continue to expand human rights and freedoms and maintain its long-standing cooperation with international organizations. However, members of FATO should not be given the opportunity to abuse human rights mechanisms by asserting baseless allegations. So does that mean that any organization who raises human rights issues is to be ignored because they're Gulenist? I'm not a terrorist or a member of FATO or a Gulenist. I'm like many, many other members of civil society and the UN who are simply saying to Turkey, enough is enough. You'll hear from Johan this morning about the Turkey Tribunal. IOHR is delighted to be collaborated with the team to release a series of reports which clearly provide evidence that these abuses have become systemic in a way that the government polices its people and suppresses its opposition. I invite everyone to visit the Turkey Tribunal website and to read those reports in more detail, just to get a true sense of the current situation in Turkey. I'd like to end in calling on President Erdogan to adopt the recommendations presented in the UPR and to use his own words to become democratic, transparent, accountable, effective, and to ensure the rule of law is on an equitable basis so that the people of Turkey can enjoy the protection of their human rights and justice is given for those who've suffered so much. Thank you for Press Emblem for today's session, and thank you for your attention. Let's call on the Turkish government to stand up, to implement what they have signed up to under the human rights obligations, and to listen to what 124 countries were telling them 9 months ago. Thank you.
We thank Madam Pei very much for her very valuable contribution. Ladies and gentlemen, our second speaker is Mr. Alfred De Zayas. He is an American lawyer, writer, historian, expert in the field of human rights and international law. Between 2012 and 2018, Mr. Zayas served as the first UN independent expert on the promotion of democracy and equitable international order. At present, he teaches international law at the Geneva School of Diplomacy. He will also deliver a video recording speech. Please welcome him, and the floor is his.
Good morning, good afternoon. My name is Alfred De Zayas. I am former independent expert of the Human Rights Council for the promotion of a democratic and equitable international order. And I am honored to be invited to say a few words in this side event concerning the independence of the judiciary in Turkey. Besides my experience as independent expert, I was for a couple of decades staff member, senior lawyer with the Office of the High Commissioner for Human Rights, secretary of the United Nations Human Rights Committee, and also chief of the Petitions Department, meaning registrar for the communications coming in under the optional protocol to the International Covenant on Civil and Political Rights, of which, of course, Turkey is a state party, and for the procedures, the petitions procedures of the Committee Against Torture, Committee on the Elimination of Racial Discrimination, Committee on the Elimination of Discrimination Against Women, etc. So, without further ado, let me say that I have read the memorandum drafted by my colleague Diego Garcia Sayan, the rapporteur on the independence of judges and lawyers, and I share his concerns fully, and I endorse his recommendations. The issue dealt with in this memorandum is the adverse impact that the amendments to Article 159 of the Turkish Constitution, which were introduced by virtue of Act 6771, have on the independence of the judiciary and the separation of powers. I mean, we all know, we're all Democrats, that a democracy depends on the separation of powers, and that if there's no independence of the judiciary, then democracy will not function properly. So it's in the interest of the United Nations, it's in the interest of the Council of Europe, it's in the interest of the Venice Commission that Turkey adjust its legislation and its practice to international standards. The very valuable memorandum of Diego Garcia Sayan indicates that this Act 6771 of 11 February 2017 introduces amendments to the Constitution of Turkey, and in 18 articles, which modify 50 constitutional provisions and repeal 21 other procedures, that this act actually undermines the independence of the judiciary in numerous ways. Now, the European Charter on the Statute of Judges and And the Council of Europe's recommendation on judicial independence is something that we want to really recommend that the Turkish authorities look a second time at and adjust its legislation and practice accordingly. Now, all of this will be discussed, no doubt, in the Universal Periodic Review of Turkey. We just had the Universal Periodic Review in 2020. There will be a midterm reporting in July 2022, a national consultation in July 2023, and NGO submissions are to be submitted by June 2024, and the next UPR is scheduled for January 2025. Now, we don't want to wait 4 years, nearly 5 years, until the problems of the excessive influence of the executive over the judiciary to see those things corrected. I, as former Secretary of the Human Rights Committee, I am surprised to see that there has been no more examination of Turkish reports to the Human Rights Committee since 2012, and that the concluding observations of the Human Rights Committee, which were very good and very much in point in the year 2012, are now, in a sense, outdated, because we've seen all the changes that followed the attempted coup of 2016. We have seen the tremendous number of judges and lawyers dismissed, sometimes detained, sometimes tortured, sometimes killed. Now, we have serious documentation of these abuses against the judiciary, and largely in total impunity. Unfortunately, the world is so complex, and there are so many grave violations of human rights worldwide, that not enough attention has been brought to bear on the situation that obtains today in Turkey, and the persecution of political opponents, the detention and arrest and torture of dissidents in Turkey. As you know, or maybe you don't know, for 7 years I used to be the president of the pen club here in Suisse Romand, that is the Association of Writers and Journalists, Poets, Essayists, Novelists, and by the way, we will be celebrating 100 years since the founding of the pen club. Now, the pen club has issued over the years, I would say, dozens of resolutions concerning Turkey, concerning the violation of freedom of opinion, freedom of expression, and the persecution of journalists. I think, if I'm not mistaken, no country in the world today has as many jailed journalists as Turkey. And a tremendous number of Turkish intellectuals, professors, judges have had to flee the country. Now, this is a situation that deserves world attention. And I think that it's time for the international community, and in particular for the Human Rights Council, to establish an international commission of inquiry to look into the human rights violations occurring today and occurring over the last 4 or 5 years in Turkey, and to make constructive proposals how to improve the human rights situation in Turkey. As I said, I very much endorse the recommendations of Diego Garcia Sayan. I will read two of them. The government and the Grand National Assembly should, where relevant, reconsider the changes to Article 159 of the Constitution with a view to ensuring their compliance with existing international and regional standards relating to the independence of the judiciary and the separation of powers, review the composition of the Council of Judges and Prosecutors. Right now, the composition of this CJP is so much under the influence of the president that you cannot call it an independent organ. So review its composition so as that the judges and the prosecutor members of the council are elected, not appointed, are elected by their peers, following methods guaranteeing the widest representation of the judiciary at all levels. Remove the discretionary power of the President of the Republic to select any members of the council, etc. I suppose that Diego, when he speaks to you, he will go in detail into these very concrete proposals that he makes. And that, of course, is the function of rapporteurs. We're not here just simply for the purpose of naming and shaming. That is part of it. It is important to identify the problems, the violations of human rights standards, etc. But more important than that, it's not just the shaming aspect or the embarrassment that flows from being caught violating human rights standards. What is important is that we make constructive, pragmatic proposals that the government will be able to implement. And that brings me to another topic, also a recent document addressed to the government of Turkey. We have here dated the 26th of August of 2020, a memorandum signed by Fionnuala Ni Aolan, the Special Rapporteur on the Promotion and Protection of Human Rights and Fundamental Freedoms for Countering Terrorism, signed by Elena Steinerter, the Vice Chair of the Working Group on Arbitrary Detention, signed by Irene Khan, the new Special Rapporteur on the Promotion and Protection of the Right of Freedom of Opinion and Expression, Clement Niatelosi-Gule, the Special Rapporteur on the Rights to Freedom of Peaceful Assembly and Association, Mary Lawlor, the Special Rapporteur on the Situation of Human Rights Defenders, and of course, our friend Diego Garcia Sayan as Rapporteur on the Independence of Judges and Lawyers. Now, here we see a complex which is not limited to Turkey. Many countries have been abusing the concept of terrorism in order to suppress political dissent. So anyone who holds opinions that are not in conformity with those of the government is at risk of being defamed, denounced as a terrorist, and then suffering the mobbing and the humiliation that goes with it. I believe that the recommendations of this document also deserve attention by this side event and by the Human Rights Council. I think a lot of explanation must be forthcoming from Turkey. For instance, here is a question addressed to Turkey. Please provide information of how the definition of terrorism in the anti-terror law number 3713 is construed. Please explain how the anti-terror law is compatible with the obligations of Your Excellency's government. Of course, we know that it is not compatible, but we want to reach out to the government and say, we know you have a problem, let us help you. Let us help you solve this problem in a constructive way through a constructive dialogue. Now, the whole human rights system of the United Nations, under the leadership of Michelle Bachelet, our High Commissioner for Human Rights, with the human rights treaty bodies, notably the Human Rights Committee, the Committee Against Torture, the Committee on the Elimination of Racial Discrimination, etc. All of these bodies are there actually to help governments improve the human rights situation in their respective governments. It's not a question that we independent experts or special rapporteurs or experts sitting in the Human Rights Committee simply want to criticize, condemn, denounce. We want actually to help, and we want to convince Turkey that it is in its own interest to cooperate with the Office of the High Commissioner for Human Rights, to accept advisory services and technical assistance so that the Turkish people can better enjoy their human rights and fundamental freedoms. I would like to encourage Turkey, as a matter of urgency, to forward to the Human Rights Committee and to the other treaty bodies the outstanding reports that have not yet been submitted. And I also have a plea to the government of Turkey, to wit, that it release political prisoners, that it stop the persecution of judges and lawyers, and that it provide a measure of reparation to the families of Turkish lawyers and judges and journalists who have been dismissed, who have lost their employment, and who are suffering misery, basically, because of political persecution by the government. I mean, it is time for Turkey to embrace the human rights principles contained in the International Covenant on Civil and Political Rights, in particular, Article 14 thereof, which is the article on the independence of judges and lawyers, and also the relevant provisions of the European Convention on Human Rights and Fundamental Freedoms, and that it accept the advisory services and technical assistance of the Council of Europe, of the Office of the High Commissioner for Human Rights, and of the Venice Commission. I thank you for the opportunity of saying these few words. I salute my colleague rapporteurs, in particular, my friend Diego Garcia Sayan.
We thank Mr. Zayas a lot for his very comprehensive speech and crucial recommendations. Now, ladies and gentlemen, let's welcome our third speaker, Mr. Johan van der Noot. He is a Belgian politician and law professor at Ghent University. Between 2011 and 2014, he was Deputy Prime Minister and Minister of Economy, Consumer Affairs, and North Sea in the government. He got retired very recently, but still active professionally and committed with human rights issues. And right now, he is online with us. Welcome, Mr. van der Noot. The floor is yours.
Hello, thank you very much. I would like to take the occasion to give a little bit explanation about the initiative we take about the Turkey Tribunal, and also take some conclusions of what has been said till now. First of all, the Turkey Tribunal, we are working on 6 reports. Report of torture was the first one that already has been published, and the same with the abductions report. And the report about impunity will be published now in 1 or 2 days. It's ready. And the 4th one is the press report. That should be ready in 10 days, something like that. On top of that, we will have a report about medical aid for people who are in custody and the situation of lawyers in Turkey, which for the moment is very, very difficult, as everyone knows with the last week's arrests. It was clear again that the intimidation of lawyers and punishing of lawyers, getting them in jail is quite very threatening for every possibility of defending in a normal way people who are becoming before the judge. Now, the reports are not completely done yet, and we will have our tribunal one of the next months to come, and we were happy to find some excellent judges. We have 6 people from different continents and with experience, three persons who were judges at European Court. We have someone who has experience in the American system, someone who has experience in the United Nations system, and from South Africa also someone who has more African tradition on human rights. So we're very happy with that, but I think it is now already possible to have some very first conclusion. I would also mention, and for that I am linking it immediately with the initiative of today, that is that we are planning to have an activity for 1 week actually, but during that week we will also have a kind of a side event. It's a bit strange name, with a manifesto about independence of the judiciary. And why that will be done, I think it is, let's say, it is essential if we want to speak about the rule of law in a democracy, that you have 3 elements that are essential. First one is that we have free and democratic elections. As far as Turkey is concerned, although there are problems, and that also, for instance, in the local elections afterwards, there were quite some problematic situations, also dismissing mayors in the Kurdish region and so on, but still, as far as the elections are concerned, until now we can say there are free democratic elections, which is the first element to have a rule of law in a democratic society. However, that's not enough. It's not enough to have elections. The only way to have a rule of law and to say that you have a real democracy respecting human rights, you need counter powers. You need the judiciary that should be independent, and you need a press that is independent. And I think you cannot talk really about a democratic system with respect of human rights where normal procedures are possible if you do not have elections, free press, and independent judiciary. It's essential. And the report about the freedom of press will be published in 10 days, I think. That's clear. And I think it's even a bit, how to say, it's a bit cynical, or I don't know how to denominate it, to still publish a report on the freedom of press, because it's so clear. When you have, the country has probably the most journalists of all the world in jail, then it looks like a bit masochism to still do the effort to write and read about it, because it is clear that the counterpower of the press in Turkey is nearly inexistent, with one exception still, that is the possibilities that some internet websites and so on have to a kind of a digital press, a digital freedom of expression. And we all know that the new laws that have been voted are trying to destroy also this last element of the freedom of the press and freedom of expression. The freedom, the independence of the judiciary, I think the Kampala judgment of the European Court is a very rare but very clear example how the European Court of Human Rights has been judging how judges exactly work in Turkey. We should not underestimate legally and this judgment, because it clearly says, listen, the case against Kavala is something that the judges, I am a bit, let's say too blunt, but that's something that the judiciary had to do because the president asks. That's what he says. That's clear. And that, of course, is stunning. It's for a country that's the member of the Council of Europe. This is more than worrying. This is frightening. This is perhaps most of all because the silence that is still within the European context about it is completely unacceptable if we compare to the importance and the gravity of the situation. So I think that for the moment, and some authors have already been describing that Turkey, we should not longer say it is a democracy, it is what they call a competitive authoritarian system, meaning it is authoritarian, there are no counterpowers, but still competitive in the sense that there are still elections, as far as now we can still say that. But that has some consequences, of course. We have seen that the last 10 years, perhaps more, all these counterpowers really has been destroyed. We can now give some good advice, and I agree with the former speaker that we should be very clear, detailed in what has to be done. I completely agree on that. But I also think that we have to face the situation that without a monitoring from outside, and we can think about the United Nations Commission, we can think about the Council of Europe, we can think about several instances, but without monitoring from outside, it will not be possible to bring back this independence. The problems that have been caused, the interventions, the structural destroying of this independence has went so far that we cannot think but just changing the law, just changing the composition of the High Council or whatever, that it will work. It will take years to bring the independence back, to make judges not being afraid that in 2 years it will change again, that they will be put in jail again or dismissed again. The impact of these last years is horrible, I think. And so I think we have to be clear in what should be done. But I have the impression that, and that's my strong belief, that the restoration of not only the elections, but the freedom of the press and the independence of the judiciary will need clear help monitoring from outside to convince the people inside that for this time it is for real. Democracy has one very good characteristics. It's like nature, perhaps is democracy kind of our nature. That is that it can restore very fast. We see how nature can come back after a destruction. And I think also system, a society that has come into an authoritarian system can come back fast. Democracy can be restored. The judges can get the message very clearly that they're independent. The press can get new chances, but we cannot think that this restoration, this bringing back all the elements of a good democratic society with the respect of the rule of law will really get back, will really get confident if they have to do it alone in their own Turkish situation. The tradition, the past, the different coup d'etat, the different stories that have been there, the tradition is too strong to convince people that's to step in a new era. So I would like to join the memorandum, to support it as much as possible, because I think it's really needed. But I would like to add, if I see from my point of view, that the international community, be it European or be it universal, will have to give concrete, very detailed monitoring and aid to really convince the actors on the field of the press and of the judiciary that for this time, it is a serious attempt to restore the freedom of the press and to restore the independency of the judiciary. Thank you.
We thank Mr. Van der Lenot very much for his very important speech and his recommendations. Now, ladies and gentlemen, our last but definitely not least speaker is Mr. Kutlan Menderes Elmas. He is a former Turkish judge. He worked as a judge for more than 10 years in Turkey. He has 2 master's degrees. He is also an alumni of Michigan State University College of Law. He is with us now, and he will deliver an online presentation. Please, Mr. Kutlan Menderes Elmas, the floor is yours.
Thank you. I would like to thank you for this opportunity, and I'm honored to participating in this side event. I would like to begin my speech with a general information. As you know, Turkey faced a coup attempt on the 15th of July in 2016. Lots of questions have been asked around this dark incident, but we have not been able to learn the basic facts yet. Whoever was standing behind this coup, this attempt, something was wrong. Before securing the streets and suppressing the attempt, the prosecution office of Ankara launched investigation against more than 2,500 judges and prosecutors before the sunset. The investigation was not against the putschist, but against judges. It was around 1 a.m. In the morning. And the accusation was to attempt to abolish the constitutional order and constitutional orders of the state and throw away the democratic government. Based on the list that was prepared before, an arrest wave began in the morning of 16th of July. We say that that list was long before prepared, because on the list there were some judges and prosecutors who were previously passed away or retired. Among these judges, 2 members of the Constitutional Court, Mr. Alton and Mr. Tercan, 5 members of the High Council of Judges and Prosecutors, and more than 100 Supreme Court judges were arrested. their bank accounts and assets were freezed, and their passports were revoked. Even though these judges, including me, had nothing with the coup at that night, the prosecutors and the peace panel magistracy applied flagrante delicto provisions and issued arrest warrants. This was the first step towards the new regime, a new state, and the judiciary should have been taken under absolute control. The prosecutors were claiming that these members of the judiciary were acting in the same direction and under the same motivation with the putschists. But they didn't show any concrete evidence proving this accusation. When we understand now, the aim was obvious: to pave the way to a system in which President Erdogan would be immune to any kind of judicial action, or in a large definition, to immune himself to the rule of law. The number of the dismissed judges reached to almost 5,000 in the following months until today. And this amounts to the 1 out of 3 of the total judges as of 2016. More than 3,000 judges, and by judges, I'm referring to the judges and prosecutors both. More than 3,000 were put under detention, and hundreds of them, in particular Supreme Court judges, were put in solitary confinement. The government, the Ministry of Justice did not provide official numbers, but we are estimating that around 700 judges are still in prison, either in pretrial detention or as convicted. Yet around 1,300 judges have been convicted, but we don't know how many of these convictions were upheld. And as of today, 500 judges and prosecutors were acquitted. And the problem is around 100 judges, including women judges with their small children, are still in solitary confinement. Former council members, former Supreme Court judges are still in solitary confinement. During this time period, 5 judges passed away in prison, namely Seyfettin Yiğit, Mustafa Erdoğan, a Supreme Court judge, Teoman Gökçe, former members of the council, Mehmet Tosun, who was around 28 years old at that time, and another young judge, Abuzer Kara, passed away because of the serious health problems. Another problem that judges have been facing is ill treatment complaints. In the recent weeks, and a Supreme Court Judge, Hüsamettin Uğur, has claimed that he was beaten up by the prison guards. His daughter, through his social media account, revealed this problem, but the prosecutors basically ignored his allegations and closed the case. He has been in prison cell all alone since 2016. The tragedy is not limited to the judges personally, but also their families have been suffering. They have been humiliated and mobbed, and they have been denied and deprived of basic human rights. They have lost their salaries, but they have not been allowed to work in private sector. And furthermore, who wants to help these families are prosecuted under the terror crime provisions by the Turkish authorities. And we all know that the members of the European Judges Association and who helped some families were investigated last year or the year before. And these investigations against the families cannot be explained with any legal argument. But this includes a clear message to the standing judges. This message is clear: do not stand by the law and do not try to stop the president or the government. Instead of the dismissed judges, around 11,000 judges, new judges and prosecutors were employed. And through this re-employment, now the judiciary is running as an arm of the state. They don't care any local or international legal criteria. As President Erdogan once said, we don't care about what the European Court of Human Rights says. We will continue our way. Another step toward a non-independent judiciary was the constitutional amendment took place in 2017. Through this referenda, President Erdogan literally changed the state. The three branches of the Turkish state was given under the president's absolute control. The structure of the judicial administration was fundamentally changed. First, the word, the high or supreme, in its title was removed. Some can say that the respect or honor did not derive from the title, but why did they need to change the title? Because they don't want any high council. And more important amendment is with its members, about members and their appointment procedure. As you know, the majority of the council before had been elected by the peers, but according to the new law, this process was waived, changed, and all members would be, are appointed directly or indirectly by the president. And now I would like to mention about the Alparslan Altan case and the approach of the Turkish Constitutional Court. As you know, Alparslan Altan and Erdal Tercan, Professor Tercan, were the two members of the Constitutional Court. Altan was also the vice president of the court, and Mr. Tercan was, and still is, a well-known law professor. He worked at Ankara University Law faculty for long years. Violating the procedural guarantees for judges, which was more strict for Supreme Court judges, both were arrested the following day. Their procedural objections were dismissed and they were sent to the prison. After exhausting the domestic remedies, Mr. Altan took his case before the European Court of Human Rights, as you know. And in this case, the European Court found violation of Article 5, paragraph 1, right to liberty and security. The European Court of Human Rights did not accept the flagrante delicto arguments of the Turkish government. And the court also stressed that the prosecution process was in violation of the constitutional and provisional safeguards of judges. However, neither the Constitutional Court nor the Court of Cassation, as the first instance panel chamber, refused to follow the decision of the Human Rights Court. His trial was not revoked, and unfortunately, he's still in prison. I don't know any decision about Professor Tercan, but even if the European Court of Human Rights did not decide, or the Constitutional Court did not decide over his case, the same arguments can be said over his arrest and trial, and he is still in prison. The European Court of Human Rights also found violation in the case of Hakan Baş, who is another judge, but the panel courts and the Constitutional Court are still ignoring them. We know it, and the Constitutional Court officially declared that they will not follow the decisions of the European Court of Human Rights. In Yıldırım Turan case, who is another judge, it's an interesting case. The Turkish Constitutional Court did not find any violation, and the reasoning of the court was as follows. Referring to the European Court of Human Rights ruling delivered on the pre-trial detention of another member of the judiciary, I will quote the exact words of the Constitutional Court. The Constitutional Court said that while the European Court of Human Rights rulings remain binding for Turkey, the interpretation of Turkish laws on the imprisonment of members of the judiciary pertains to the Turkish courts. Turkish courts are much better positioned than the European Court of Human Rights for defining and interpreting the provisions of the Turkish law. These sentences are from the official decision of the court. basically, the Turkish court described the European Court of Human Rights divergence from the Turkish courts in interpreting national law as unacceptable. It is not the first. It's not the first violation of the Turkish Constitutional Court in this context. And the interesting thing, the Turkish Constitutional Court, or from whom we are expecting justice, dismissed its own members from their post under the decree number 667 on 4th of August in 2016. The court based his decision to the information gathered through the social circle and the common conviction of the remaining judges of the court. They did not show any factual explanation or evidence by which they were convinced, but they were convinced. So they did not hesitate to remove their two colleagues from their profession, and they did not since then they did not change their decision. So we are not surprised by the Turkish Constitutional Court's approach. But the interesting and of course sad thing is that the European Court of Human Rights still tends to accept the Turkish Constitutional Court and the other domestic courts as an effective and most exhausted remedy. Of course, it's not quite understandable that the hundreds of cases brought before the court have been waiting for almost 4 years. But we are complaining about the European Court's unwillingness over the applications based on the arrest process, after which thousands of judges have been convicted. And another problem is coming. Their convictions have been started to be decided by the Supreme Court. That means they can be put in prison again shortly. And we are still waiting for the European Court of Human Rights decision. A few words, I would like to say a few words about the latest Turkey visit of Judge Spano, without knowing his motivation and aim. But if I had any chance, I would like to ask his opinions after his visit. He visited President Erdogan, who had said, they don't care what the European Court of Human Rights says, referring to the decision of Demirtaş, the Kurdish politician. He visited the Speaker of the Turkish Parliament, who called the parliament to re-adopt the death penalty. And during his visit, the deputy chair of the ruling party, Cahit Özkan, addressed to the press and stated that the death penalty must be reinstated. Judge Spano also visited the chief judge of the Turkish Constitutional Court, who officially declared the European Court of Human Rights as inadequate in interpreting domestic laws. After 4 years, I can say that President Erdogan has always found a way to eliminate his opponents using his own strategies. Before, the trend was labeling and accusing some intellectuals as nationalist or ultra-nationalist or pro-Ergenekon, referring to the name. But the new trend is FETÖ or Gülenist, being Gülenist. If you are using these elements as a key charge, nobody can help you in Turkey. And that is what not only judges and prosecutors, but also the Kurdish people and the other opponents have been facing. More than 150,000 public servants have been dismissed since 2016, and they have been humiliated, mobbed, and they are isolated from the society. And we know that recently the lawyers, around 100 lawyers, were arrested, and they were accused of providing legal help to the FETÖ suspects. And it's, of course, unacceptable. I would like to finish my speech here, and I would like to thank you for your patience and attention. I am honored, one more time I would like to say, and I would like to thank to all who have been dedicated their work to the human rights problem in Turkey. Thank you.
We thank Mr. Elmas for his very interesting speech, and sorry for this disturbing sound. Again, thank you very much for all speakers for their comprehensive and interesting contributions. All right, ladies and gentlemen, now we come to the questions and answer session. Since we have only 12 minutes, we will not be able to address many questions that were sent to us during this event, but we will try to do as much as we can. And therefore, I request our host to display the first question. I see that the first question is coming from Mr. Thomas Stedelman. I think most of us already know him. He is a Swiss lawyer, a federal judge, and the board member of European Association of Judges. In autumn 2018, he published the book, Democracy Falling Apart, on the development of the justice system in Turkey. He included the articles of Turkish jurists who have been subjected to human rights violation. The book explains the role and function of the basic principles necessary for a democratic state of European character. And his question is addressed to both Mr. Van der Noot and Mr. Elmas, and it reads like this. I have a question for all the speakers and the moderator. Mr. De Zayas mentioned that the human rights bodies are not just help the government to better comply with the human rights existence Turkey signed for. He said a key is to show the government that's in their interest to adopt proposals made by the different human rights bodies. I think that's a crucial remark. But is there any hope that the Turkish government, especially President Erdogan, might see that a chance of policies would have benefit not only for the Turkish people, but also for the current government? Do you see a way to promote this approach? Is there anything we can do about it? And I don't know which of our speakers would like to answer this question. Mr. Van der Noot?
Yes, sorry, I had a bit myself. Yeah, okay. But I think it's always a question if we have to answer this, and it's often also a question that is asked about why we took the initiative for the tribunal. The question is can we expect that the actual government is indeed really interested? Will it be in, you said in the question was said, it will not only be positive for the citizens, the Turkish people themselves, but also for the government. I think that, to be honest, we passed a little bit this period. The government at a certain moment was, and we have seen that in our torture report, that at a certain moment the situation under the government got better. We saw changes in the situation of very hard torture that was before, that very slowly things were better. So there was a program of the government to make things better and more transparent and so on. However, I think that unfortunately, at the moment, we must admit that that is not the case anymore, and that the government has been mixed up in so many cases of torture and abductions and hard violations of human rights, that at the moment there is a real independence of the judiciary and a real freedom of the press, the existence of the government, and also the impunity of some members of this government will be at stake. So I should say, we should hope that indeed your remark is true. I'm a bit doubtful that it is, because I think if you see atrocities that have been committed, and with abductions, with long taking in custody people without informing their family, not knowing where they are, the torture, I think, and I'm not speaking about the prosecutions that were started before about corruption and so on. I think the actual government has a lot to fear when human rights come into force again, and I think they are aware of that. So unfortunately, I'm a bit less hopeful, but yeah, we have to be hopeful anyhow for humankind's sake. But I'm less hopeful than sounds from your question, actually.
Thank you, Mr. van der Noot. And now the second question. A former military diplomat, Hüseyin Demirtaş, has asked a question. I think this question is addressed to Mr. Elmas. When we look at the Turkish Constitutional Courts and also the European Court of Human Rights decisions, we see that in the beginning of their decisions, they put some irrelevant and deceptive information about 15 July attempt as facts with the applicant's personal situation. Is it a legal or impartial attitude? Mr. Elmas, please.
When we read the facts from the Tron case, I noticed 2 or 3 basic information, false information. The first information is the Constitutional Court in paragraph 117 stated that the prosecution against judges was launched following days after suppressing the attempt and securing the streets, which is basically not true. The tanks were on the streets at that night, and the bureaucrats of the judiciary gathered together around 11 p.m. And at that time, the fight was ongoing. And so the, excuse me, so the Constitutional Court is manipulating. But when we read the decision of the European Court of Human Rights, decision in the case of Alparslan Altan and the facts, I cannot completely agree with the question and with the comments, because the judges, the European colleagues, have been careful enough in what they are doing. So in the beginning paragraphs, what they are stating is, to me, to understand the factual situation in a chronological and understandable way. They don't show, or it is not easy to conclude that they are approaching to the subject matter of the application as what in the comment was stated. So I'm still hopeful, even if it's late, but the European Court of Human Rights will fairly decide over the cases. Thank you.
Thank you, Mr. Elmas. Ladies and gentlemen, we still have many questions, but we have reached the time limit dedicated to us today. And therefore, we come to the end of this side event. We would like to say thanks again for all the speakers for their informative and interesting talks, and to the audience for their active participation. Thank you for your attention and joining us today, and have a great rest of your day. Goodbye.